Okay, I've had a sandwich and I'm armed with another cup of coffee. So I am good to go, and we are going to get into topic 6, which is international law. And the first question is, or should be, is there such a thing as international law? And yes, there is, and no, there isn't. Typical lawyer, right? the the difference between international law and municipal law, and here municipal law doesn't mean of a municipality or a city or a town. Municipal law is the law of a country. Okay, so the municipal law of Canada is common law, with the exception of Quebec, where the municipal law is civil law. Municipal law of France is civil law, that sort of thing. So the difference between municipal law and international law is that municipal law has prohibitions and punishments. If someone breaches your contract, you can sue them. Now, the punishment is not really, like a fine or imprisonment. It's that you get a judgment against them for a monetary amount or an injunction or something like that. And then the courts provide a system where you can enforce those judgments through garnishing orders, payment hearings, seizure and sale of assets, registering against land, and that sort of thing. So there's a method whereby if you are wronged, you have access to justice. Whether you get justice or not is another question entirely, and we could spend, 5 or 6 terms discussing that. But at least you have the prohibitions and punishments. Internationally, sometimes you do and sometimes you don't. One article I read said that there was no policeman on every corner internationally. In other words, there was no way of policing and enforcing certain actions against people who have in some way wronged you. Another article which you have in your materials is called The Perils of Legality. Now, the reason that article was written was completely different than I think what I want to look at in terms of its content. What it was about was during the George W. Bush period in the United States, the George W. Bush wanted to invade Iraq and go after Saddam Hussein and finish a job that he thought his father, the other President Bush, failed to complete. So the United States invented this whole concept of weapons of mass destruction, and and we're trying to get the United Nations to form a peacekeeping force and go in there. And the author of the article said, "Oh, the United States will rue the day that they actually went to the United Nations to get approval." Because in the when Iraq invaded Kuwait, the Security Council of the United Nations said, "Let's form a peacekeeping operation." All countries brought in military personnel, mostly the United States, but Canada was there, Britain was there, France was there, Germany was there, and they went in and they fought the Iraqi army and kicked them out of Kuwait. But they got the United Nations approval for that, and the author said, "Oh, that was the worst thing you could possibly do," because now that ties the hands of the Americans. Anytime they want to do something in the world to further their position, the presumption will be that they actually have to go to the United Nations and get approval, and that's exactly what happened with George W. Bush. He wanted to invade Iraq, and the United Nations said, "Not until we can actually determine whether or not there are weapons of mass destruction." So George W. Bush managed to get a coalition of a few countries together and went in and did it himself. Britain joined them. Canada refused. And the author said, "Man, we shouldn't have done that, because there you go. See, without United Nations approval, everybody's critical of our actions." Well, that was the point of the article, saying, let's not do that anymore. If we want to do something, let's just go in and do it, because we're big and we're strong and we can do it and get away with it. But while he was talking about it, he said that there really was no international law that there's the United Nations trying, and there's a WTO trying, and there's the International Court of Justice trying, but there's really no conformity of rules and punishment. He did say that there are law-like regimes. So, for example, there are some international laws that function really quite well. There's the International Convention on the Carriage of Goods by Sea, which regulates seagoing traffic. And if you have a problem with that, then you can actually access the International Court of Justice to enforce your position. There's the International Carriage of Goods by Air. There are some other conventions like the United Nations Convention on the International Sale of Goods. So and these have access to court systems and provide some rules, conformity of rules and punishments. And yet there is a lack of anything like a concrete body of international law. So in slide, let's see, oops, oh dear, there we go. In slide 45, we start off with discussing what the international law regulates. And they regulate relationships between states and other states. They also regulate the things between states and foreign persons. And then they also regulate relationships between persons of one state and persons of another. So on screen 45, numbers 1 and 2 would fall under the concept of public law. The state on one side, a state on another, the state on one side, a person on the other. And then the third item is really people on one side and people on the other, so that falls under the heading of private law. So we got public law, which deals primarily with the rights and duties of states and intergovernmental organizations as between themselves. And then private law deals primarily with the rights and duties of individuals and non-governmental organizations in their international affairs. In private law, I think when we were discussing the Canadian legal system, I talked about the scale of justice and listed some things that were public law and other things that were private law. Well, what we've got here is pretty much the same thing. On the public side, we've got the sources of international law as set out by the International Court of Justice. Then we've got law that governs international personality. Are you a native of this country? Are you a citizen of that country? Do you have dual citizenship? State territory, it deals with the concept of a state by itself. Then there's the law on state secession. We see that happening in Africa, where there were large colonies dominated by a European country, and when those broke up, initially a big state would be formed, and then smaller states would break away from it. We saw that in India with Pakistan and India after England left. We almost saw it happen in the United Kingdom when Scotland had a referendum to see whether they would leave the United Kingdom. We see it periodically cropping up in Canada when Quebec gets upset and they want to, leave Confederation. There's talk in the United States about Texas seceding from the Union and things like that. So that's state secession. Then there's the law of the sea, and we've already talked about that. There was this body of sort of customary law of the sea, and it has been replaced by the International Carriage of Goods by Sea Act and another statute which deals with the law of the sea. We have international dispute settlement bodies of all kinds. We've got the International Court of Justice, we've got international tribunals, international arbitration, that sort of thing. Then there's a law of war, and I think the law of war is if I'm bigger and stronger than you, I win. but there's a whole body of, how you're supposed to treat prisoners and things like that. Then there's state responsibility with respect to aliens. Again, these are not little green men that come down from outer space and say, lead me to your taker. What we're talking about here is someone comes into Canada, they are an alien. And we have some responsibility towards them, and then they have some responsibility towards the state of Canada. That's on the public law side. Then on the private law side, you see these private law matters that we're more familiar with. Non-commercial private matters like torts, it's battery, assault, false imprisonment, passing off, intentional interference with contractual arrangements, negligent misrepresentation, product liability, things like that. Then we have estate law. That's very much a private law matter. Someone dies in the province of British Columbia. They may own property in the United Kingdom, but they actually have to get probate in British Columbia, which means a document that allows the representative of the estate to then divide up the assets, give it to the heirs or beneficiaries. But what about that property in England? Well, there's nothing Canada can do directly, the person in Canada. What they have to do is they have to get a certified copy of the grant of letters probate here, take it over to England, register it with the court system there, and then the estate can be dealt with. So it's very much a private law matter. Nationality is a private law matter. My niece has a dual citizenship with Canada and the United States, but the laws of the land require that she say which country that she is associated with for the purposes of voting. Okay, and then marriage and divorce is very much a matter that is in Canada handled differently than other countries. So it's very much a private law matter. There are some reaching across borders. For example, if you leave your wife in the province of British Columbia and take off with all the money, and you go down to Tennessee, the wife over here is owed, no longer called alimony, but they're owed some money from the estate, and they will get a decision in a court here. How can that affect you in Tennessee? Well, you go to Tennessee and you live there for a while. They're going to ask you to get a Tennessee driver's license. Try to get a Tennessee's driver's license. The law is that you owe money to somebody in BC on a family law matter, you got to pay it, or you don't get your license down there. So there's some cross-border aspects to it, but basically marriage and divorce is a private law matter. It gets even more confusing because marriage and divorce is pursuant to the federal statute, where we have the provincial statute of family law, which also impacts the same relationship. Okay, those are non-commercial. Now we get to commercial. This is contracts. This is the one we're primarily going to be concerned with because it's doing business cross-border. It's a private law matter. I have a contract with somebody in Mexico, and we give them the product and they fail to pay us. I have to sue them here under BC law, or I have to make the decision to go down to Mexico, to the state of Jalisco, for example, and sue the defendant there. We have some leeway now with the arbitration. As remember I said that an arbitral award here is enforceable there. So we're getting some movement towards having an international body of law. Money in banking is commercial and it's private law. The Bank Act governs in Canada. And then we have transportation. This is very much a private law matter. Transportation goes cross borders, so there's conflicts, but that has to be resolved in a private lawsuit. Financing, this is loans and mortgages and things like that. Again, very much a domestic municipal law scenario. Securities, we all have our own system for buying and selling shares and taking security on assets and things. And then intellectual property. We have the World Intellectual Property Organization, which is trying to give an international flavor to that. But the way it still works is if I file a trademark in in Canada, it's a federal state. File it in Canada, I cannot then say under the World Intellectual Property Organization, I get to enforce my trademark in Australia. I have to file a trademark in Canada. The WIPO allows me to then file in those other jurisdictions a little more easily than otherwise, but I have to enforce my trademarks in the various countries. Okay, so that's the distinction between public law and private law. The next slide, we get into the sources of law. And the sources of international law were itemized in the International Court of Justice statute. Okay, so the United Nations passed a statute called the International Court of Justice Act. Okay, and in that act, in Article 38, Sub 1, it lists the sources of international law that the International Court of Justice can use to resolve disputes. Even though that is just for that particular court, it's a nice compact listing of the laws in the international sphere. And there's 5 of them. There's treaties, conventions, international customs, general principles of law recognized by civilized nations, and then the judicial decisions of municipal courts and the teachings of the most highly qualified publicists of various nations. Let's look at these individually. Treaties. Treaties are really nothing other than contracts between states. Okay, if I have a contract with a business in Mexico, that is not a treaty. That is a private law contract. But a treaty is very much a public law instrument, and it's nations that decide that their interests are common enough that they should have a contract for some purpose. They don't call it contracts, they call it treaties. These are binding agreements between 2 or more states. A bilateral treaty is a treaty like Canada had with the United States when they had the first Free Trade Act, the FTA, the Free Trade Act. Canada has a FTA with Chile. We have one with Israel. We have them with a number of countries. Oh, and Colombia. We send them who knows what. They send us drugs? No, coffee. Anyway, and then you have multilateral treaties. What used to be called NAFTA and is now, I should go into my screen right now and make that change. It's now called the U.S. Mexican-Canada Agreement, the USMCA. The USMCA is a multilateral treaty because it involves 3 countries and governs the free trade between those 3 countries. There's self-executing treaties and then there's non-self-executing treaties. Self-executing treaties are effective when a ratifying state signs it without domestic enabling legislation. What's that mean? Well, Canada and the United States entered into the Columbia River Treaty. And that did not require the House of Commons passing a statute adopting it. Canada signed it, the United States signed it, bingo, you got your treaty. A non-self-executing treaty is the one that we have under the USMCA. Canada signed it, the United States signed it, Mexico signed it, but it did not become effective until each country then passed enabling legislation adopting it. So our House of Commons passed legislation adopting it. The United States passed legislation adopting it, and as did Mexico. There's another reference to the North American Free Trade Agreement, which I should change right now. Okay, the United States Mexican Free Trade, Canada Free Trade Agreement is divided up into a number of parts, okay, but parts 11, 19, and 20 are the three most important. The part, one of the problems in international business is business in one country might like to make an investment in another country, and then they make that investment, and then that other country confiscates that investment and provides no compensation whatsoever. So under the USMCA, if the United States makes an investment in a plant in Mexico and then Mexico decides to nationalize that plant, take it over, they are required to give compensation to the United States. And if they do not do so, or if the compensation the United States thinks is inappropriate, then under Part 11 there can be a tribunal set up and there'll be an investigation and a decision. 19 is Part 19 is just the section on interpretation disputes. So you draft an agreement of that size and complexity. There are going to be things put into that agreement that countries look at and interpret differently, and so they get into a dispute about that. So rather than just canceling the treaty, you can ask for an arbitration, and a tribunal is set up, and they decide how to interpret that. Part 20 is the one that is the most significant, or has played the most significant role, and that is when one of the very first disputes that arose under this, and this section was applied, was when raspberry growers in the province of British Columbia had more raspberries than they could sell domestically, and so they sold the raspberries in Washington State, and the United States can't remember the federal government agency that looks into this, said that was dumping. They were selling it in the United States for less than they were selling it in Canada, and so they assessed duties on this on these BC companies. So it's actually the United States under this treaty applying extra nationally applying their laws. They're applying duties on the raspberry growers. This went to an arbitration. It was the very first one, and it was pursuant to Part 20, the anti-dumping arbitration, and the tribunal that was set up. At that time, there were only 2 countries in the free trade agreement. So what they did was they had 2 Americans arbitrators and 2 Canadian arbitrators, and then those 4 chose a 5th, and it turned out it was an American, and everybody went, "Oh, okay, 3 Americans, 2 Canadians. You know how that's going to come out." Well, in actual fact, Canada won that one because the only way you can determine if the product was dumped is if you have really good prices of what is sold in Canada and what is sold in the United States. And most of these companies were selling internationally, or in Alberta and in other countries, rather than domestically. And so the United States said, "Oh, well, obviously the price in the United States is less than in Canada," and Canada took the position, "Well, there's no price in Canada," and so the United States says, "Okay, well, if there's no price in Canada, then obviously it's being dumped in the United States." And the tribunal said, "No. The other provision is that if there's insufficient sales in BC to get a really good idea what the price is sold domestically, then you can look at these other sales." And so the tribunal found in favor unanimously for Canada, and the duties were dispensed with. There's an extraordinary challenge provision, and the United States immediately launched an extraordinary challenge, and that was based on the only basis for an extraordinary challenge is that there was bias in the decision of the tribunal, and the extraordinary challenge tribunal said, "Well, shows the bias. 3 Americans, 2 Canadians, and the Canadians win. Like, where's the bias here?" And it was unanimous. So, where's the bias? And the United States could not point to any real bias. And they were just surprised that they could possibly enter into an agreement that wasn't going to work in their favor all the time. Anyway, since then, there were a long series of disputes, and Canada was winning them all. And then lately, the United States started winning them, and along comes Trump, who says, "Hey, that's unfair. We have to do away with that." Okay, there's just another Trumpism. Canada negotiated as hard as we could, and it turned out that that provision was left in there, even though Trump wanted it out. It had worked really quite well and had been lately working in the United States' favor, so the U.S. negotiators left it in. And then there's this Article 2022, which provides for private arbitration. And I already talked about that when we talked about arbitration under the Canadian legal system topic. British Columbia has an arbitration act, so a BC business goes after a BC business. They apply for arbitration under that act. If BC business wants to go after a European business, then they go under the International Commercial Arbitration Act. Well, before this last round of negotiations, which came up with the USMCA, the negotiators got together and they said, NAFTA is working really well, which made it odd that Trump was upset about it, but it was working really well, so how do we make it better? And what they said was, well, we got this investment dispute arbitration, which helps some private companies, but it's an action between one of the governments and the other government. And then we have this interpretation mechanism, so we can resolve disputes on interpretation. Then we got the anti-dumping provision, which works really quite well. But that's all government. So what happens if Peter Holden sells milk to a company in Mexico and the company in Mexico does not pay? That has nothing to do with anti-dumping. Okay? That has nothing to do with interpreting the agreement. That has nothing to do with an investment dispute. So there was no mechanism in the North American Free Trade Agreement that allowed me to access arbitration under the umbrella of NAFTA. Well, under the USMCA, we now have this Article 2022, which provides for private arbitration. It was brought in just before the renegotiation of the agreement, and it's still in there. And what it did was it said, okay, we'll have arbitration centers set up under NAFTA to resolve private law disputes, to help with the private businesses, encourage trade. And they said, okay, we need centers in all the countries. So there's a business in BC dealing with business in Mexico. If the Mexicans want to do arbitration, they go to the Mexican City Arbitration Center. And if there's a problem between the U.S. and Mexico, they could go to the arbitration center in New York City. Why New York City? Because they've had one there for years and years and years and years and years and years and years, since the early 1900s. In Canada, you would expect that the arbitration center would have been in Ottawa, our capital, or you would expect that it would be in Toronto, one of the major commercial districts. But no, it was in British Columbia because we have the oldest and the longest operating center, and it was granted to the BC International Commercial Arbitration Center. It says that right in the website for this provision. They call this the centers, the commercial Arbitration and Mediation Centers of the America, CAMCA. And the CAMCA Center is in Vancouver. Now, there is one in Quebec City because the nature of the civil law versus common law, Quebec is always, saying we get the short end of the stick. So they said, we are a country doué, so we want our own center. So they granted one, and it is in Quebec City. But there's very little trade between the United States and Quebec. And so there's very few disputes, and they don't go to CAMCA. As a matter of fact, CAMCA has not yet been used, as far as I know, by Canada. And I don't know about the other countries. So we have this system there that's ready, willing, and able to be used, but hasn't been used to date. Okay. All right. So that is the North American Free Trade Agreement. Now, some terminology. Plenipotentiaries are the people, the individual heads of the government, the Foreign Secretary, Secretary of State, that have full power to negotiate treaties. Okay. The Secretary of the State in the United States and the Foreign Secretary in the United Kingdom, or the Minister of Foreign Affairs in Canada, don't get involved in it. They always delegate it to a group of people that really know something about commerce, and they get together and negotiate it. The other term is pacta sunt servanda, which is an important Latin term which stands for the proposition that agreements must be served. So this would fall under the concept of agreements like treaties, but it's the basis of pacta sunt servanda is what they call general principles of law recognized by civilized nations. So we have a method where we've explained how you get into treaties. How do you get out of them? Well, you can give formal notice, and that's what Trump was threatening to do. Give formal notice and just back out of the agreement. And he said it'll be over tomorrow, and all those jobs that went to Canada will come back to the United States, which isn't true. But anyway, that's what he was saying. But it's not that simple. Okay, some treaties you could give notice and bingo, it comes to an end. NAFTA, because it is so incredibly complex and is thread through our commercial systems, it would actually take 10 years to withdraw out of the U.S. Mexican-Canada agreement. And because there's all sorts of side agreements with respect to energy and agreements with respect to water and things like that. So it's much more complex than Trump sort of thought. Because, he couldn't handle that sort of intellectually. So how do you get out? Well, you give formal notice is one way. There could be a superseding treaty. So we had the Free Trade Act between Canada and the United States that was superseded by the North American Free Trade Act, which has now been superseded by the USMCA. And then the last one is terminated when the purpose is fulfilled. And I'm desperately looking for an example for that. So if you find an example of a treaty involving the three countries that we're talking about, North American countries, and you provide that to me in an email, there'll be a bonus of 2 marks for you. A treaty that has been terminated because its purpose is fulfilled. I thought I found one, and that was the Columbia River Treaty between Canada and the United States, because I thought its purpose had been served. But there was then an article in the newspaper last year, just about November, where they're talking about how there were some things that now had to be updated in that treaty. It's kind of an interesting story because it goes back to this whole concept of conformity of laws and punishment. Okay. The United States in the sort of around 1950s, decided that they were going to build a dam, a hydroelectric dam, on the Columbia River, which winds its way up into Canada, then turns around and goes back in the United States, and up into Canada, and eventually goes out to the ocean in Washington, between Washington State and Oregon. And they said, look out, Canada, because when we build that dam, it's going to create a huge lake behind it, which will go across the border. And there's a town up there, your town, that's, you better get those people out of there, or it'll be flooded. And Canada said, you can't do that. And they said, sure you can. It's called riparian rights. You have the rights. If you're upriver, you have the rights to control the river. And Canada said, no, that's inappropriate. So Canada brought a suit with the International Court of Justice in The Hague under the auspices of the United Nations. And they went there and they fought the case, and America defended its rights, and Canada said you can't do that. And the International Court of Justice found in favor of Canada. And so the United States said, who cares? You got your decision. Big deal. We're going to build the dam. What are you going to do about it? And so Canada looked at it and said, okay, hydroelectric power, we need that too. All right, well, United States, we're going to build a dam. And they began to seriously look at building this dam on our side of the river. And, you better tell the town on your side of the border because it's going to flood it. And the United States, you can't do that. And Canada said, well, yes, we can because you're going to do it. And so they got together and they negotiated and they signed the Columbia River Treaty so that they could build dams that would not impact towns, and they would share the electricity, and they resolved the situation, okay? But that was like in the 50s, and I thought, it's solved the problem, but apparently there's some ongoing matters, and the treaty's still in effect, okay? All right, but it was interesting, and it showed that the United States sort of attitude towards, we're big, we can do what we want, and if you get a decision in a court against us, like who cares? Because how are you going to enforce it? They don't always do that, and quite frankly, there's situations when Canada has come to the assistance of, or United States has come to the assistance of Canada in these matters, and I'll talk about those later. Okay. So that's treaties. Conventions. So treaties are contracts between nations. Conventions, on the other hand, are laws passed by the United Nations, and all the countries in the world can then either decide whether they opt in or opt out of those laws. Okay, so conventions are binding agreements. Again, a contract is a binding agreement, but these are binding agreements between states sponsored by an international organization. That's the only difference, right? So it creates only a political or moral commitment until a country passes municipal enabling legislation. So two examples. There's the United Nations Convention on the International Sale of Goods, and when I was preparing to teach international trade and law, I thought I'd better get a copy of that agreement. So I went down to the courthouse library in the Supreme Court building downtown. We didn't have it in the Capilano University Library, and I began going through the statutes of Canada, the laws passed by Canada, because I wanted to find the enabling legislation. Canada had to pass this law, or this convention, which would make it the law of Canada. And I could not find it. And I thought, okay, that's really weird. I'm doing something wrong here. So I went to the law librarian, pardon me, and I explained my problem. And she said, well, you had to look in BC statutes. And I went, oh, yeah, okay. Under the division of powers in Canada, civil and property rights, provincial rights, right? So contracts are civil matters. And so obviously, each province of Canada would have to pass a statute adopting this convention. So I went to the BC statute, and sure enough, there was an act to incorporate the International Sale of Goods Act into Canada. There's the Convention on the Unification of Certain Rules Relating to International Carriage of Air Act. This actually decides how much money you'll be compensated if your carry-on luggage is lost, how much you get if your baggage is stowed and lost, and how much you'll be compensated for injury or death. Now this transportation falls under Section 92 or 91 of the Competition Act, so it's federal. And so in the federal statutes, there was this act adopting that statute. The one that we're going to deal with a bit in this, well, two of them. One is the United Nations Convention on the International Enforcement of Arbitral Awards, Foreign Arbitral Awards, and then the other one is the International Sale of Goods Act. Customs. Now, so far so good. It's been pretty certain that those are sources of law, and you can see how they are established and how they are administered. When we get into the next two categories, we go from a degree of certainty to a degree of jello. I don't know, something that's just not very firm. So the third source of law outlined in the articles of the International Court of Justice is custom, rules which have been around for such a long time or are so generally accepted that they are described as customary law. And then number 4 is general principles of law recognized by civilized nations. Okay, now these two are a bit murky. So customary law means that these rules are incorporated into the laws of a country by a doctrine called the doctrine of incorporation. Customary international law is a part of the domestic law to the extent that it is not inconsistent with laws. So if there was a customary international law on, I'm trying to think of something, on how we treat prisoners of war, okay, there's one. And then Canada decides to pass a statute on how we treat prisoners of war, and it's either better or worse than the international custom. Then the international custom is no longer the law of Canada because it is inconsistent with a specific law. But these are matters like non-refoulement. There is a fundamental principle that forbids a country receiving asylum seekers from returning them to the country from which they came if they are going to be in danger in their home country. So someone seeks asylum in Canada, we cannot just turn around and send them back. Okay, we have to take them in, we have to protect them, we have to decide whether or not they are actually under some sort of threat, that they are actually asylum seekers, and if they fit the criteria, then we give them sanctuary, and if they don't, then we're entitled to send them back. But we cannot automatically send them back. It's a customary law, and one of the things about customary laws is, let me go down 2 slides. There's this concept of persistent objection, okay? So persistent objection means if you say, no, it isn't our law, no, it isn't our law, no, it isn't our law, then you don't have to follow that customary rule. The difficulty with that, of course, is that the customary rule, how long do you have to persistently object? And we can see the United States with the way they're treating asylum seekers at the Mexican border, the people seeking asylum from the Latin American states, is inconsistent with the international rule, and so the United States is not specifically required to follow that customary law. That customary law is followed by Canada, followed by many other countries. Countries that are bordering on Syria or places like that where there are huge numbers of people that are being murdered and raped, and their laws are their assets are being confiscated. They flood across the border, and it puts tremendous strains on certain countries. And they why do they even let them? Well, there's this international customary rule that non-refoulement, which says that they're supposed to do that. Okay. Okay, so that's one example of customary rules. Another is the concept of lex mercatoria. Lex mercatoria is Latin for commercial law, and it's a body of commercial law used by merchants throughout Europe during the medieval period, and interestingly enough, it evolved in a similar manner to the development of the common law in England, and it also transcended boundaries. all the countries of Europe, all the business people in Europe began to abide by these rules, as did business people in England. They developed their own laws, they developed their own court systems, and it was a functioning system of law on the mercantile routes. It became the international law of commerce and has since started to be absorbed by the laws of the various states. Another really good example of customary law is that law developed by Genghis Khan. He was a brutal conqueror who swept across a huge portion of the country and murdered and conquered. But whenever he conquered an area, he would try to instill legal concepts there to have order. And one of those really interesting ones is that it included, he created the concept of immunity for ambassadors. So after he had his little empire, he said, okay, I need to deal commercially with the rest of the world. And if I wanted to deal on a commercial basis with the European countries, if they sent people here and we murdered them, not likely they're going to want to do commerce with us. So he said ambassadors from all other countries in the world could come to his country safely. Okay, and there's no ambassadors act, there's no ambassadors convention. This is just a law that he created to serve his own needs that became accepted everywhere. Okay, so that an ambassador comes to Canada or a consul general comes to Canada, they can get parking tickets, and they're unenforceable against them. That sort of thing. It's always an irritation, because the police the bylaw enforcers, downtown will see a car parked and they'll start to write out a ticket for the car, and then they'll see it's the Mexican consul general, and so they know that ticket is not going to get enforced against them, so they have to throw it out. Anyway, Genghis Khan started that, and now custom includes the immunity of visiting foreign heads of state. Okay, we talked about persistent objection. Customary law is the law of a country unless they persistently object against it. And then there's the doctrine of incorporation that says customary law is applicable domestically only after it is adopted by legislation or court decisions or local usage. Okay, so local usage is when it's informally adopted, and the legislation is when the legislature or House of Commons says let's pass laws and adopt it, or the third way is a court says that becomes the law of the land. Then there's this thing called number 4, general principles of law recognized by civilized nations. And I'm trying to figure out whether there's very many civilized nations in the world or not. It seems to me that there has been, over the last 3 years, a lot of very uncivilized activities that have taken place in the United States, which one would have thought of as a civilized nation. The United Kingdom, which you would think is a civilized nation, or France, you would think was a civilized nation, do some very uncivilized things. But it's the wording that's used. Okay, so I'm just going to run with it. But I think when we say modern civilization, we're giving ourselves a pat on the back where none is deserved. There's a lot of things that happen that are very uncivilized. Okay, enough said. I'm getting down off my my soapbox. The concept of general principles of law recognized by civilized nations is a concept that is unclear and controversial. But it may include such legal principles that are common to a large number of systems of municipal law. Some examples are lashes, good faith, res judicata, and the impartiality of judges. Okay, lashes. Lashes is a French term which has been used in English courts, which means delay. Okay, justice delayed is justice denied. Obviously, in a criminal matter, if someone is incarcerated and they don't go to court and they don't go to court and they stay incarcerated and they don't go to court, then that whole delay prejudices that person's case, okay, to the point where cases have actually been dismissed against them. In commercial matters, justice delayed is justice denied. The pandemic has actually created a difficulty for one of my former clients is being sued in small claims court. It's a bogus lawsuit, but the claimant is claiming that he's an employee when he was actually an independent contractor, so is not entitled to compensation. But anyway, he had a couple of people that he was going to call as witnesses, and lo and behold, one of the witnesses moves out of the country, and there's no way he's going to be able to get that person to come back to be a witness in the trial. And another of his witnesses actually passed away. All right, so he files his notice of claim, and we're waiting, and we go through the settlement conference, and we're just about to get to court, and the pandemic hits, and the court says everything's on hold until 4 months later, and during that time period, one guy leaves and one guy dies. That prejudices his claim. Okay, now that really isn't an example of lashes, because lashes would be if my client did something to delay the case. All right? So if you delay and you delay, then that delay will be may become a defense against your action. Good faith. Let's see. Can't remember, there's a Latin term for that that'll pop into my head. But you cannot come to court with dirty hands. So in other words, if you have committed a wrong, you don't get to come to court to claim compensation if that wrong relates to the action you're taking. Oh, now it's going to bother me that I can't remember the Latin phrase. Anyway, so you have to do these things in good faith. Res judicata means you have to be very careful when you sue somebody that you sue the right person. When I was an articled student with the law firm of Raycon, Lightbody and Reynolds, Lightbody was probably one of the best litigators around. And there was a fellow who went into the Lionsgate Hospital, the Vancouver General Hospital, for a routine operation, and came out with a whole bunch of damage being done to his leg. And obviously someone had been negligent. Now, there was the surgeon. If Wally had sued just that surgeon, and it turned out that that surgeon wasn't at fault, then he can go and he can sue the orderly. Then he can sue the anesthesiologist. Maybe it was the nurse that didn't give proper care, and then he goes and sues that person. You cannot do that, okay? If you sue the wrong person, it's res judicata. You don't keep getting to go to court until you find the right person. So when Wally Lightbody started the case, he sued the family doctor, the two surgeons that did the operation, the orderly. He sued the doctor that did the rounds. He sued the nurses in the operating room. And he sued the anesthesiologist, and he sued the nurses in the recovery room. He sued everybody, okay? Because that way, as he started doing some investigating, when he finds out that the nurse in the operating room had nothing to do with it, then he can drop her from the lawsuit. And the orderly wasn't in the operating room when the problem happened, so they drop him from the lawsuit. And the the anesthesiologist, it was nothing to do with the anesthetic, so you can drop him from the lawsuit. But you have to make sure that you sue the right party. If you don't know who the party is, then you sue John Doe, okay, and then you do some investigation until you find out who the right party is. So res judicata just means already decided. Okay, you don't keep getting to come to the lawsuit until you finally win. You lose, you sue again, you lose, you sue again. No, you can't do that. It's res judicata. The impartiality of judges, not an issue in Canada. We don't elect judges. They're not political. They may be small L liberal or small C conservative, but they're not members of the Liberal Party. They're not Conservative Party members. They're not New Democratic Party members. So they're appointed through the law societies so that there's impartiality. Not the case in the United States. For years in my office, I had a sign, "Elect Judge Joe Smith." I got it from a campaign office when we went down to Washington State on a visit. They were having their elections down there. And I went, whoa, they elect their judges. Elect John Smith, Republican. Anyway, judges should be impartial, and in most civil law jurisdictions and common law jurisdictions they are. It's only a real problem in the United States, as far as I know. There may be corruption of judges in Mexico, but they don't belong to a political party that I know of. Okay. So international tribunals, meaning, and they use tribunals in sort of a very broad sense. The International Court of Justice, the WTO, all those places rely on these principles when they cannot find authority in another source of law. So if you've got case law, or if you've got a convention, or if you've got a treaty, that supersedes the general principles if they conflict. So you don't have to look at general principles if you already have a statute or something like that. But in absence of those things, then they look for these general principles of justice. The last category falls under the heading of judicial decisions and the decisions of teachings of the most highly qualified publicists of various nations. What this is the various the International Court of Justice, for example, can look at decisions from the BC Supreme Court. They can look at decisions from the court in France or Italy, and because these are judicial decisions of judges. One of the problems is there's lots of areas where there's unsettled law as of yet. And the international enforcement of judgments was one of those unsettled areas of laws, and that's what a large portion of my article on the convergence of the legal systems of the world talks about. But in the absence of case law, then there are professors of law or people of that have written textbooks on these matters, and the International Court of Justice is entitled to look at those. So in the material, I make reference to the Sharn Importing versus Babchuk case, and I'm going to do a separate little video on that and bring in some diagrams. I usually circulate the case in class and talk about it, but because of the distance education now, I can't do that. So we're going to look at it differently because it's a very important case. So that's an example of case law which provides guidance as far as what international law should be. The interesting thing about that case is it also makes reference to the teachings of legal publicists. There was areas involved enforcement of a legal matter between BC, Alberta, and Quebec, and questions about cross-border application of laws came into question, and there was no judge-made law that they could look at, and so what they did was they looked at the writings of one of the best legal scholars in Canada who had thought about these issues and said what he thought should happen in these situations. And I have one of these very old textbooks in my office, and I wish I could circulate it with you, but that would just be a disaster. Okay, I might have coronavirus and hand the textbook to one student who then looks at it and hands it to the next student, hands it to the next student, and we're all ill. So we cannot do that, which is unfortunate. But in that book, it was really interesting because I was looking at the enforcement of judgments across Canada. Could a BC judgment be enforced in Ontario? Could an Ontario judgment be enforced in Alberta? Could an Alberta judgment be enforced in Quebec? And I found some interesting things. Since the beginning of Canada, there's been a lot of animosity between Ontario and Quebec. Okay, less so now, thank goodness. But for years, it was terrible. Anyway, shortly after the turn of the 19th century, it was very clear that a BC judgment would be accepted for enforceability in Quebec. There was no law that said they had to, but they were being, okay? And but an Ontario judgment couldn't, okay, because of the animosity between them. And then we get what's called the Reciprocal Enforcement of Judgments Act, where all the provinces have agreed that between themselves their judgments can be enforceable. And when you look down the list, all the common law provinces say yes, and Quebec is absent from that list. So it's kind of interesting. Anyway, the Charn importing case not only outlines a lot of the law with respect to taking jurisdiction and application of what law, but it also shows perfectly the application of teachings of the legal publicists. All right. And what you can see from this is the potential for legal conflicts, the laws of two different jurisdictions that conflict. And this is literally called conflicts of laws. And as my legal career advanced, I began to do more and more international trade law, and I found it one of the most fascinating areas because there was so much development going on, and there was so many potential pitfalls that it made it very interesting to practice that kind of law. So conflicts of law says if both the forum state and another state has some legitimate interest in the outcome of the case, then the forum state must choose what law to apply. The forum state. What was the forum state? Well, the forum is the court or tribunal where the trial or hearing will take place. Okay, jurisdiction is, does that forum have the authority under which the court or tribunal has the right to hear the case? And then the law is, okay, they have the right to hear the case, but what law should be applied? And there are rules with respect to that. So we're going to break it down between criminal matters and civil matters. Okay, just remember back to that diagram. A criminal matter is public law, and a civil matter is private law. Well, internationally, the way you decide what the forum is, whether the court has jurisdiction, or what law should be applied, follows that same division. The rules with respect to criminal law are relatively straightforward. The rules with respect to civil law, yahoo! It's wonderful. It's like a smorgasbord for lawyers because you just have so many potentially interesting factors to take into account. We'll look at the criminal law matters, and then we'll break in this part. So, criminal matters. Jurisdiction. Really, there are 4 ways that a court can take jurisdiction in criminal matters. The 5th is something that was used in the past and hasn't been used for a lot of years, so the question becomes whether or not it really is. But the nice thing about having 5 of them is it would make a really good Part B exam question where I have a question worth 5 marks. Okay, so jurisdiction. How can a court take jurisdiction over something? So a crime is committed in British Columbia. If the accused is a Canadian citizen, because it's a federal statute, the court can take jurisdiction on the basis of the nationality of the accused. There's also the possibility that you can take jurisdiction based on territoriality. So a crime has been committed in British Columbia, but by an American. Well, we cannot take jurisdiction based on nationality because he's not a national of Canada, but we can take jurisdiction based on territoriality because the crime was committed here. Then there's two that don't come up very often in Canada anyway, far more often in the United States, where they've created so many enemies around the world, and they're fighting terrorism and everything, that they have to have these. The first one is the protective principle. It turns out that somebody comes to Canada that is dangerous, okay, has committed a crime somewhere else. But we can take jurisdiction over that person and charge them with a crime based on the protective principle. We're actually protecting Canadians, okay? And then there's another category where we get our hands on a Osama bin Laden type person, or Saddam Hussein type person. They haven't committed any crimes in the United States or in Canada, but we take jurisdiction over them because of the universality principle. Okay, we're protecting the world. And when the Americans managed to get their hands on Saddam Hussein, they were going to try him, bring him to the United States and try him based on the universality provision. They decided not to do that. They decided to have him put on trial in his home country based on nationality, which is a smart thing to do, I think. But there is this possibility that a person might commit a crime in another state and come to your state and you can grab them. Well, they didn't commit the crime here, but you're using the protective principle because they're liable to cause a problem here, and they did commit a crime elsewhere. The passive personality one is we get our hands on somebody who killed a Canadian somewhere else in the world, because the victim, the passive personality, the victim was a Canadian. We can take jurisdiction over that person. So there's 5 of them, and there may be a problem on the exam, midterm exam, saying, Joe Smith committed a crime in Canada, but he's an Australian. How could Canada take jurisdiction over that person? Okay. Now the 3 things are the forum, the law, and whether you have jurisdiction. Okay. Well, you look at those 5 things to determine how you find the jurisdiction. The forum is automatic. The forum has to be the municipal court of the state where the crime has been committed. Okay, so or where the crime is going to be punished. So the forum would be the municipal domestic criminal court in every circumstances, because we're trying the person here. So where's the forum going to be? Oh, Detroit? No. Why? How about Paris? No. Why? It's got to be here. Okay. The law to apply is, well, we cannot apply the Texas law, criminal law, here. Okay. We cannot apply the law of England here. We have to apply the Canadian Criminal Code. Okay. So the law is the Municipal Domestic Criminal Code, i.e., in our case, the Criminal Code of Canada. And then the only thing that could muddy the waters is perhaps there could be concurrent jurisdiction in a criminal law matter. And that came up in an international case that went to the Permanent International Court of Justice, which wasn't very permanent because it was formed under the League of Nations. And with the start of the Second World War, the League of Nations fell apart. You have to remember that after the First World War, all the countries got together and they said, let's not have this happen again. Let's form an international body. And the United and they formed the League of Nations, and everybody had a vote. And the United States said, whoa, we're more important than everyone else. So, we want some sort of control here. So if we can't control this, we're not going to be a party to it. So they weren't a party to it, and they didn't fund it. And it turned out to be a very ineffective body. Now, it did some really good things. It passed the International Carriage of Goods by Air Act, the International Carriage of Goods by Sea Act. Those have lasted, okay? But they formed this international court, this permanent international court of justice, which lasted until about 1938. So it wasn't very permanent. But one of the cases it heard was a French ship in the Mediterranean ran into a Turkish ship and killed some Turkish sailors. And the ships managed to get dragged back to Turkey, I think. The French first mate, who was at the helm when this happened, was put on trial for murder in Turkey. And France said, no, he should be returned to France and he should be put on trial for murder here. And Turkey said, no, he committed a crime and killed Turkish citizens, so he gets put on trial here. And they had the matter referred to the Permanent International Court of Justice, who was then going to not determine whether or not he was guilty. So that was not a contentious jurisdiction. It was a advisory jurisdiction. So they weren't going to say he was guilty. What they were going to say was who could try him to find out if he was guilty. And they passed the buck, basically. They said that there was no international law of the sea at that particular point in time, which would say who had jurisdiction. And so they said there's concurrent jurisdiction. He could be tried in both places. We don't allow someone to be tried for the same crime twice inside Canada, because that would be double jeopardy. But they said two nations had concurrent jurisdiction. So that could muddy the water. There could be concurrent jurisdiction, which may require some sort of a diplomatic solution as to where he's going to be put on trial. All right, that brings us to civil law matters. And let me just see how long I've been going. I've been going 1 hour and 11 minutes. So I think what I'm going to do is I'm going to end here, and we'll say this is International Law Part 1. And then we'll come back next time, because I think I'd like to have a diagram which I can put on Moodle. We used to call it Moodle, and that sounded like Moodle Noodle. It didn't sound very professional, so they now call it eLearn. It's exactly the same thing. So I'm going to put it on eLearn. So excuse me if every once in a while I forget and call it Moodle. So I'll put it on Moodle, and then you'll be able to look at the diagram and understand better what I'm talking about. All right, so that's enough for now. Thank you very much. Hi again, NABU students. We are deep into international law, and last class we started talking about the sources of law, and when we got down to judicial decisions, we then entered into the area of conflicts of law. When there's a court case that involves parties from two or more different jurisdictions, then you have a potential that the laws of those various jurisdictions will conflict. That puts the courts in the position where they have to decide not only what forum is appropriate and what law should be applied, but also who has jurisdiction to hear the matter. In criminal matters, we saw on slide 60 that the forum is automatic. The forum is the municipal courts of the jurisdiction of where the crime has been committed. The law to be applied is again the law of the land. So in Canada, the law would be the Criminal Code of Canada. Where there is some degree of latitude for the courts is in the area of jurisdiction. Courts can take jurisdiction over a criminal matter based on 5 principles, 3 of which are not used very often, particularly in Canada. Those are the protective principle, the universality principle, and the passive personality principle. The first 2, though, however, nationality, the nationality of the person who has committed the crime, and territory. Those are the main ones that are used. They're relatively straightforward. But then we get into slide 61, where we start dealing with civil law matters. And for this course, because it's basically directed towards commerce as opposed to law generally, we're going to look at contractual disputes and how the courts decide forum, law, and jurisdiction. And the first thing you have to realize is jurisdiction is taken on the basis of the real and substantial relationship doctrine. Okay, what relationship do the parties have with the dispute, and which one is the most significant? Okay, the real and substantial relationship doctrine. There are two ways they can take jurisdiction under this category. The first is based on the in personam jurisdiction. In personam just means the person. Okay, so does the party provide the court with the jurisdiction to hear the matter? And the other is in rem jurisdiction. In rem just means the assets, the subject matter of the contractual dispute. So that's how they do jurisdiction. Forum, it is the Municipal Domestic Civil Court. And then the law is based on the most significant relationship doctrine. Okay, and this is where there is a lot of interesting things that take place in the court case, because before the judge can actually start making a decision, the judge has to be confident that they have this jurisdiction. So the most significant relationship doctrine has 5 aspects to it, and this is almost always on the exam, either in question 1, part B, or it'll be in the problem itself. The first is the place of contracting. Can the judge look and say, okay, the contract came into existence in BC, ergo BC gets to take jurisdiction on that basis? If that's unclear, then they can look at the place of negotiation. Did the parties go to Manitoba and negotiate the contract there? Did one of the parties from Australia come to Ontario and do it there? And so they look at the place of negotiation. They look at the place of performance. Okay, they went to various jurisdictions at different times and hammered out different parts of the contractual arrangement. So you cannot say where it was negotiated or the place of contracting. But can you look at it and say, okay, it was to be performed in British Columbia? Performance is, there's a difficulty with that too, and because performance, for me, if I'm providing you property, is what I want is money, right? So I figure it's performed when you've paid me. You, on the other hand, say no, performance occurred when they provided us the goods, okay? And so that's not terribly clear in every case either. And then, of course, is the location of the subject matter. Is this a purchase of property or a lease with the mineral rights? Is that property in British Columbia? Is it in Brazil? That sort of thing. And then lastly, they look at the nationality, domicile, residence, or place of incorporation of the parties. And they don't necessarily look at for one of these. They look for a number of those factors which may indicate that the court has the right to choose, the law of that particular jurisdiction. And we will look specifically. I'm going to see if I can either set it up as a Microsoft Teams session. We'll look at the Sharn importing case because it involved 3 jurisdictions with civil law and common law, and the common law of 2 jurisdictions is actually not identical. And so we're going to look at that case so that we can better understand how that operates. How the court approaches it, I guess, is the best way to look at it. Is the first thing they do is they check the contract. Does the contract have a choice of law clause? If there's no choice of law clause, then they go to the significant relationship doctrine. If more than one law applies, then I just want to make sure I get this correct. So I'm looking at the screen. If more than one law applies or the proper law is from another jurisdiction, can it be proved? So we'll see that in the Sharn importing case. Finally, the judge said, okay, the forum is Vancouver because that's where they started. But what law is to be applied? and the judge actually came to the conclusion that Quebec law should apply. Now, he had taken jurisdiction in Vancouver, but the question is law, so they said law should be applied. And then the question becomes, the Quebec law is to be applied, but in court on that day, can the lawyers prove Quebec law? In other words, can they provide in evidence of what Quebec law should apply? All right. If they cannot do that, then the judge gets to decide what law to be applied. And ultimately, in Charn, as we will see, the judge said, okay, nobody can prove Quebec law. That's the proper law, so I get to choose law. I'm going to choose BC law. And then after doing all that, the court says, all right, let's look at the doctrine of foreign non-convenience, which means the judge is going to say, is there a more appropriate court that could hear this? Is it, so there's the plaintiff is here, but the defendant's there, and they have 5 witnesses. Is it appropriate that the defendant has to travel to BC with their 5 witnesses, or might it be more appropriate for the court to declare the foreign non-convenience, which means there's a more appropriate court, a more convenient court that it can be heard, or subject matter, or as well as the people, there's articles that might be introduced as evidence. Is the subject matter of the contract mobile enough that it can be brought to BC so that the court can take it as an exhibit, or might it be more appropriate to go elsewhere? So those are the 5 steps that the courts take. And heads up, I think that's really important, so be prepared to find that on the exam. Okay, so the important stuff is on slide 64. And the courts will look at those five factors and decide whether or not. Now, the key thing about the when you get down to, well, no, let me back up. The key thing is this is a real problem. So you go back to number 1 on the list. Check the contract for the choice of law clause. Okay, and that is a risk management measure that should be applied in almost every contractual agreement. Is you put in a choice of law clause which says this contract shall be governed in accordance with the laws of the province of British Columbia and to the exclusion of conflicts of laws, and bingo, there's no longer a problem. Now, why do you put in the exclusion of conflicts of laws? Because there was a contract a number of years ago entered into, the party said BC law shall apply, and then the judge of another jurisdiction said, I don't think the BC law shall apply, even though the contract says that. I think the law of Missouri should apply, or it should also be taken into consideration, and there was a great deal of difficulty in getting an appropriate decision in that case. And so you always say, let's exclude conflicts of laws. Okay, so that concludes a very short conclusion on international law for the course, and from here we'll be going on to business organizations, and that will be topic number 7. And we'll be looking at sole proprietorships, partnerships, corporations, and we'll also be talking very briefly about societies and cooperatives, only as it pertains to incorporated entities that have some sort of limited liability. Thank you very much. All right, we are going to finish off international law topic 6 with a close, hard, in-depth look at the Charn Importing Ltd. Versus Babchuck case. Although this is a Canadian case in the sense that it involves Canadian jurisdictions, because it goes across provincial boundaries, the same laws and rules that are applied to international cases involving 2 different countries were applied in this particular case itself, and it's got everything. Okay, so the first time we bumped into Sharn importing was on slide 56 when we were talking about the sources of international law outlined by the International Court of Justice in Article 38 of the convention that established it. The fifth such rule was that the courts could look at judicial decisions and decisions of the teachings of the most highly qualified publicists of various nations. And this is, in fact, evident in that case. The next slide I wanted to point out, of course, is that this deals with 61, where we talk about civil matters. Okay, it's not a criminal matter, it's a civil matter, it's a contractual dispute. Jurisdiction, form, and law. How do we work it out? Well, in Sharn importing, the plaintiff was in Quebec, the defendant was in British Columbia. The plaintiff elected to start the action in BC against the defendant. The defendant defended by filing a statement of defense in BC. So automatically the BC court has jurisdiction. How? Well, this is an in personam jurisdiction. And if we look at slide 62, it lists those factors that the courts can take into account for determining whether or not it does have valid jurisdiction. And the first one is nationals of the forum state. What's the forum state? BC. So obviously Babchuk is from BC. Bingo, there's one. Natural persons physically present in the state. The company is in Quebec, it's not physically present, no. Natural persons domiciled in the state, no. The company is registered in Quebec, so it's deemed to be domiciled there. Natural persons who consent, okay, because Sharn Importing Ltd, through its director, started the action in BC, it was consenting to the jurisdiction. So bingo, BC has jurisdiction. What's the forum? Well, that's dictated by the nature of the action. For example, in criminal matters, it's a criminal matter, so the forum is the criminal courts. But in civil matters, it's a little less obvious because you could go to small claims court in BC or you could go to the BC Supreme Court. In Ontario, they have small claims court, they have high court, and then they have the Superior Court, I think it's called. So they have 3 levels there with different jurisdictional amounts, okay? But in BC, you got 2 choices. Well, how did we wind up in the BC Supreme Court? Because it's concerning a guarantee for a substantial amount of money in excess of small claims, okay? So we now know jurisdiction and we now know forum, but then we get to law, and this is where things get a little interesting. Choice of law, you look at the most significant relationship doctrine, and we'll see in the case that they do that. And we look at the place of contracting, negotiation, place of performance, location of the subject matter, nationality, domicile, or the residence of the incorporating parties. All right? So let's go to the case and take a look. Wilson, CJSC, Chief Justice of the Supreme Court. On page 21 of the lecture materials, and which is page 350 of the actual case, that's where the judgment starts. And after some preliminary matters, the judge says the defendant, Babchuk, lived for many years in Vancouver. Okay, and he ran his company from Vancouver, and the bank account for his business was in Vancouver. So there's the nexus. Okay, that's how they say. Okay, that's the how we can establish the forum. Then he said the issue is the execution in favor of the plaintiff of a guarantee, and what the problem is different laws, conflicts of laws. In Quebec, it would be civil law that applied. We don't even know what that's about. In BC, a guarantee signed under seal is enforceable. In Alberta, it's different. If a guarantee is signed under seal but is not witnessed by a notary public, then it is invalid or void. So Babchuk is taking the position that he gave a guarantee, but it's void. The business in Quebec wants to enforce it. So what happened? The Sharn Importing imports shoes and then sells them to retail outlets. Babcock has a store in Vancouver. He's been dealing with Sharn Importing for quite a while. He opens up another store in Edmonton. He wants to deal there. He gets the shoes on credit, 30, 60, 90 days. Okay, so he gets the shoes, sells them, pays Sharn Importing, and then makes a little bit of profit. The Edmonton store goes insolvent, and the shoes are either sold, stolen, disappeared, whatever. I suspect they probably got moved to the Vancouver store, sold, and the money kept illicitly. Anyway, the point is, Sharn Importing had been supplying goods on credit to the Vancouver operation. Now he's going to supply goods on credit to the Edmonton operation, and Sharn Importing says, well, wait a minute, okay, we're willing to do that, but we want personal guarantees, okay? So Babcock signs a personal guarantee, and then the store goes insolvent. The Sharn Importing from Quebec starts a lawsuit against Babcock. Babcock says, oh, it's invalid because it was signed in Alberta. Okay, question. Was it signed in Alberta or was it signed in Vancouver? And it's not clear, and it gets muddier as to where it was signed as we go through the case. Okay, so first thing the judge does is he looks at the document. There is nothing on the face of the document to show where it was executed. Joint and several liability, though. Okay, so they've got the manager of the store on the hook, but he probably doesn't have enough money. It's going to be a dry judgment. So they want to get the owner, which is Babcock. And it's the whole point that the corporate veil would protect the owner, Babcock, from liability, right? Because if you pierce the corporate veil, you cannot go after the owners or the shareholders. All right, the top of page 351, he said that the business, the store, Al Ronda, went insolvent and the creditors received nothing. So there were other people who owed money besides Sharn Importing, and they didn't get anything. The key point, the defendant admits that he signed the guarantee and meant to be bound by it. So Babcock says, yeah, I signed it and I meant to be bound by it, but gosh, if I don't legally have to pay, why would I? Okay? Because under the Guarantees Acknowledgement Act in Alberta, which BC doesn't have, such a guarantee had to be executed in front of a notary public. Farther down the page, we see something that happens every once in a while in court cases, and that's the shifting of the burden. Under the, remember we talked about the criminal law matter and a civil law matter, and civil law matters have to be decided on a balance of probability. Well, the balance of probability generally means that the plaintiff has to make out his or her case, okay, and find in their favor. Every once in a while, though, the judge says it would be inequitable to expect the plaintiff to do it, and they shift the burden to the defendant, and that's what they do here. The burden and onus of proof of this defense rests on him, on Babcock. Why? Because whether it was signed or not in Alberta is within his knowledge. Sharn Importing received it in the mail after execution, so they have no way of knowing where or when it was signed, other than the fact that it was dated and signed. Okay, at the top of page 352, point 2, it says, because the fact is particularly within the knowledge of Babcock. Then he quotes Wigmore. Wigmore what? Wigmore on evidence. This is one of those qualified legal publicists that is a source of law in international cases. In a civil matter in British Columbia, you do not bring in textbooks. Okay, you do precedent, you do law. Only in rare circumstances will they bring in textbooks, and usually it is in an international case like this. Farther down the page, it starts a paragraph. I trace first the history of the pleading, asserting the guarantee was executed in Alberta. The pleadings. The plaintiff files a statement of claim, and well, they file a notice of civil claim which starts the action. Then they file a statement of claim outlining all the details. The defendant files a statement of defense. Well, Babchuk files a statement of defense, does not plead the Guarantee Act. Files an amended statement of defense when he actually mentions the Guarantee Acknowledgement Act. But he doesn't get around to actually pleading that as a defense until his third amendment to his statement of claim. So the judge looks at that, and obviously what he's saying is that's a bit suspicious. It's like, an afterthought. Hey, here's a way I can get out of paying. Then at the bottom of page 352, he says, now I'll deal with the defendant's evidence. And you can read that yourself. It was incredible. He could, I signed it in Edmonton. Well, do you have a plane ticket for when you flew there? No. Do you have a hotel ticket or receipt where you stayed? No. Do you have any meal receipts? No. But I know I was there. And then they said, okay, if you weren't there on that date, because you don't have any proof, are you sure you signed it? Oh, no, it was another day. I remember now. And he kept changing his story, and he kept coming up. Oh, I wasn't in Edmonton, it was in Alberta. Oh, I was in the States, and I was coming back to Edmonton. At one point, he even said he stayed at his sister's place, but nowhere did he have any receipts from hotels, airlines, gas receipts, or meals to suggest when he was in Edmonton at the time this document was actually signed. And at one point, when he was talking about how the judge was talking about how he changed his story, it says, after this was one idea was dismissed, this spurred him to new efforts. So obviously, the judge is just not buying this. And then at the bottom of page 353, the judge says, I found his story, or rather his succession of stories, which could easily have been verified by other evidence of friends with whom he stayed, or hotel registers, ticket stubs, completely incredible, particularly so because he is, I am sure, the sort of man who would keep most careful records for income tax purposes of business trips. So he's dealing with the veracity of the defendant's testimony. He doesn't say, he's trying to perpetrate a fraud, because fraud is so hard to prove, okay, because there has to be mens rea and actus reus there, the guilty mind and the guilty act, where if you can just say, this is a number of years after the event and your recollection is not as good as the other parties, I believe him more, then the courts can do that a lot easier, and that's called the veracity of the testimony. Okay. He said the matter to be proved was particularly within his knowledge, and he failed to do so. So he has not established that it was signed in Alberta. But that leaves open the possibility of an appeal. And this judge is very clever. Wilson was a very, very well-known judge. He decides he's going to close all the doors. He said, but if I'm wrong in this finding, and if I were satisfied that the guarantee was, in fact, executed in Edmonton, I would still dismiss the action on the grounds of the law of Edmonton should not apply to the case. Okay? Wow. On the grounds of the, okay, it was executed in Edmonton, but it still wouldn't affect it. No, I flipped the page wrong way. Sorry. I'm flipping that the wrong way again. Here we go. The Alberta law is not the proper law of the contract before me. And he cites Dicey's Conflicts of Laws, another publicist, well-qualified publicist, who set out in his textbook a number of rules. And Rule 127 of Dicey, and that's not particularly important anymore, but the idea behind the rule is, it says, you look to see the closest and most real connection. Okay, so right on slide 63, we see the most significant relationship doctrine. Same thing. Okay. Okay. First step, look at the contract. Is there a clause expressly stating the law? No. Second step, he goes to case law to support Dicey that you should look for the closest and most real connection. And he looked at the Mount Alberta Borough Council versus a defendant. Okay, and he said, all right, so how do we establish this most significant relationship doctrine? We have 5 points on slide 63, and he looks at the first one, the place of contracting. Okay, where did the parties actually contract? And then they look at the place of negotiation. So the first presumption is lex loci contractus, lex loci, the law of the place where it was contracted. And then the second presumption is lex loci solutionis, which means where the place of performance. Okay, so they don't look at the number 2 point. So he discusses them. And then he discusses the Mount Albert Borough Council case, which goes on to say, at the top of 355, English law, in deciding these matters, has refused to treat as conclusive, rigid, or arbitrary criteria such as lex loci contractus or lex loci solutionis. Why? Well, they go on to say, in each case, on a consideration of the terms of the contract, the situation of the parties, and generally all the surrounding circumstances have to be looked at. So you look at these, but you don't just say, aha, it's one of these, or oh, it isn't one of those. So these are guideposts. They're not. You're not looking for the one to put the stamp on. The place of performance of the contract was not and could not have been intended to be Alberta. Why? Well, we have the contract for shoes going, the shoes going this way and the money going that way. No, that's nothing to do with the guarantee. Okay, that's to do with the contract between the shoe selling company and the shoe supplier in Quebec. The guarantee is going to be performed by having the money paid to Chartner Importing in Quebec. Okay. The debtor is bound to seek out his creditor. That is an absolute rule. Stepping aside for a second, there was a case not too long ago that I was involved in where somebody rented premises, business premises, and they paid their first and last month's rent, and they move in, and the next month, on the first of the month, the tenant's got his check there, and he's waiting. He's got the check, and he's waiting and waiting. But the landlord doesn't come to get it, and so he goes, oh well. Next day goes by, and landlord isn't. When's the landlord going to come by and get the money? And then the third day he comes to work, and there's a lock on the door, and there's an order of forfeiture. Why? Because he had not paid his rent, and he said, but I was ready and willing and able at all times to pay my rent. And under the lease, it clearly says you have to pay the landlord. Well, that doesn't mean that the landlord has to come and get it. What it means is you have to seek out the landlord and get the money to him. And so the forfeiture held, okay? Same thing here. He has to seek out his creditor. Okay, where's the creditor? Quebec. Oh, problem solved. Then obviously, if it's to be performed, place of contracting, was it in Vancouver? Was it in Edmonton? Was it in Quebec? Was it done by mail? Was it done by telephone? So they couldn't nail it down. Place of negotiation, same thing, right? So did all these things are not determinative, but they get to place of performance. Obviously, has to be performed in Quebec. So the judge has his answer. Okay, you look at them all. All the surrounding circumstances. Well, place of performance, and then you look at the doctrine that the person has to seek out his debtor, and obviously it's the law of Quebec. So we now have jurisdiction in BC Supreme Court. We know the BC Supreme Court is the correct forum, and they apply the law of Quebec. So the judge turns and he looks at the lawyers in the courtroom and he says, okay, the law of Quebec. Who can prove what the law of Quebec is? Well, they're both common law judges, or lawyers, and they sort of look at each other and go, I don't know, I don't know. It's in the Quebec Civil Code, and I don't know. I don't have a copy. I don't know where to look. So the judge says, oh, okay. The next rule then is set out again in Dicey, where foreign law is not proved, the court applies English law. English law. Well, what English law? The English law of Alberta? No, because it's a BC court. Okay, so the judge says, I get to apply BC law. A guarantee signed under seal, valid. Doesn't matter where it's been signed. Okay? All right. So you think, okay, now we can all go home. No. Babchuk says, well, wait a minute. No. To be performed, aren't we talking about the performance of the contract? And the judge says, no, very clearly, we're not talking about the shoes and the payment for the shoes. We're talking about the guarantee. The judge isn't satisfied. He's going to put another nail in the coffin that's going to make it impossible for Babchuk to appeal. You think you have a right of appeal? No, you don't. You have to have an error at law or an error on the facts before you can appeal. So he then looks at the whole concept of the choice of law in favorem negotii. What's that mean? Well, it's a rule that isn't even on the most significant relationship doctrine. It goes to another sort of another avenue, and that is, what did the parties intend? Did they actually intend to negotiate and enter into a contract in I'm sorry, actually it is on the list. This is the negotiation one, the third point. Did they intend to negotiate and sign a contract that they knew was going to be invalid? No, obviously they intended it to be valid. So again, he cites Dicey, midway through page 356, choice of law in favorem negotii. It has been said that the court may incline towards applying a system of law under which the contract would be valid because, so it is said, the parties cannot be assumed to have intended to contract under the law by which their agreement would be invalid. Okay? And then he cites some case law, and that's the judicial decisions. And he said, obviously, they intended a law to apply which would enforce the contract because words out of Babchuk's mouth, the defendant has sworn that he meant to be bound by the contract, and this avertment appears to me to add special strength to the argument for applying the system of law under which the contract would be valid. Okay? So if we're looking down the lists, my apologies for the one slip, but they looked at the place of contracting, inconclusive. They looked at the place of performance and said, okay, that says Quebec law. Can't do Quebec law. We'll do BC law. And then just to be sure, he said, okay, let's just look at this one other point, the place of negotiation, and said, all right, obviously they could not have intended to enter into an agreement that would be invalid. So they looked at the first three things on the list. Now, the fourth thing on the list they didn't have to look at, subject matter, because there was no subject matter. Okay. Nationality, domicile, residence of the or place of incorporation of the parties. Well, those were actually irrelevant to this particular case, so they didn't look at those either. So, perfect case because it shows an international setting. It shows the application of jurisdiction, forum, and most particularly choice of law. And it also comes back and shows us how judicial decisions come into play and how the writings of qualified publicists come into play. So it's a really good case, and I really think that you should take a close, hard look at it for examination purposes, knowing the definition of pleadings, documents filed with the court in order to commence or defend against a legal action, and you should know style of cause, which is basically just the name of the case. Let's see, anything else we should talk about? No, that's about it. Now, I did mention corporate veil. But this is forms of business organization. We don't get into that a little later on. So you don't have to worry about the corporate veil comment. But the rest is good fodder for the cannon that I'm going to shoot at you in the way of a midterm examination. All right, so that concludes that chapter. Thank you very much.